Okay, we're going to switch gears a little bit here and talk about protected concerted activity. What we're talking about here is what you as a union person have a right to be able to talk about. To do that, let me talk just a little bit, take you back to PARA, the Public Employment Relations Act. This is the law that allows unions and union members to organize and to come together and form and organize and engage in lawful concerted activity. That's what the statute says. Also, Section 10 states that an employer is prohibited from interfering with public employees in their rights that we just talked about in Section 9. So PARA is what gives you the protection as union representatives to be able to assist each other, assist your bargaining unit members in all things involved in organizing and unions. So when we talk about protected concerted activity, we're going to go back to the township of Redford, and this was a case where the union president made a statement to the press about a union management dispute. Now, the union management dispute was a grievance that had been filed over the use of dispatchers as civilian dispatchers. So they've been going back and forth, the union and the employer. And then the press had contacted the union person, and the union person made a statement. And the employer had a policy that said you're not allowed to talk to the press. So they disciplined the union person. Well, the union filed an unfair labor practice, and it went to MERC, which, if we haven't said already, stands for the Michigan Employment Relations Commission. So it went to MERC, and MERC held that even though there was a policy that said the employee couldn't talk to the press, in this case, they were talking about a union management dispute. The union employee didn't disclose any confidential information. Therefore, it didn't rise to the level of anything that discipline should have come from. And in fact, the employer did not have a substantial, legitimate business justification. That seemed to be the buzzwords that were coming out of the court at that time, that the employer had to have a substantial and legitimate business justification for disciplining or precluding a union person from talking to the press. That case stood for a long time, and this is the statement that came out of the case that said even where employees' activity violates an otherwise legitimate rule, the employer must show that there was legitimate and substantial business justification for the application of the rule. That case stood for a very long time, and then following up on it a number of years later was the POAM v. Ottawa County case. This was another unfair labor practice charge that we filed, and it involved an incident. Going back to May of 1994, there was a jail escape, and the union had filed a grievance, and there was discussions because there was a lack of manpower in the jail. And then following on the heels of that in December, there was another escape. 2 inmates escaped. In fact, during the escape, a Grand Haven police officer, Scott Flahive, was killed. And the press had contacted the union vice president about it. Now, the union vice president made a statement, and he talked about the manpower issue and the fact that there were concerns and that the union and the employer had been in discussions about it. But ultimately, the employer, who had a rule about talking to the press, disciplined the union officer. But the court held that at that point, the MERC dismissed our charge, is what they did. And then we took it up to the Court of Appeals. And the Court of Appeals said that while they had a business justification the speech was directed at the issues, the jail staff in issues, and that while they can have their rules, they can't preclude the communication between the union and the press. And so they overturned it. Okay, more recently, the City of Cadillac. This is a case that we filed, an unfair labor practice, on behalf of a command officer. Now, what was going on in this case was the command union had given a letter of endorsement to a gal who was running for mayor. The mayor took that letter of endorsement and published it wholly in the newspaper. Once the city council saw the ad in the newspaper, they started an investigation into the union president and whether or not he had a right to do what he did. Now, he was disciplined for a couple of things. Number one, they said the city's logo on the letterhead of the union was improper. And in this case, the union's letterhead on the very bottom had a POAM emblem, and it also had the City of Cadillac logo. And there was some words to the effect of union working together with city. But the city took objection to that, and they didn't like it. They also disciplined the union president for using the city's paper and the computer when he drafted the letter. But lastly, they said that he used his official capacity as an employee. The command officer was a lieutenant. Used his official capacity to influence an election. So it went to the MERC, and the issue there was whether the city lawfully had disciplined the union president, and whether or not the union president was partaking in protected concerted activity. There's those buzzwords again. The court was identifying a three-part test. Number one, whether the actions adversely affected the employee's protected right to engage in the lawful concerted activities. The second part was whether the employer has met his burden to demonstrate, again, a legitimate, substantial business justification for the rule. And lastly, they balanced the two, the employee's rights to conduct activities that are protected, and with the employer's legitimate and substantial business justification. And in this part, the MERC came back and said a couple of things. Number one, they said, all right, the union, you're not allowed to use the logo without the city's permission. Secondly, they said that, okay, basically, even though it was kind of de minimis, if you will, that the city can say to the union, you can't use our paper and you can't use our computer. But lastly, and really we find most importantly, is that they said that they found in favor of the union on the political involvement, in that he was participating in a protected activity, and that is the union endorsing a candidate, and that was clearly protected, and there was no substantial business justification for it. So they ruled in favor of the officer. So that concludes the seminar. We'd like to remind you that there's plenty of resources on the website, and if you have any other questions, you can contact the office, or you can go to www.poam.net.